An unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Okay? Has everybody got that? Now this basic first portion of this program is designed clearly to help you. And if you take these basic cases on this one page, you will have gone a long way in getting your constitutional rights back. Okay? Now we're asking you to pay attention. Learn your Constitution. We're going to go into some heavier stuff through the second portion of this. But we want you to learn your Constitution. This book here is a citizen's rule book. It also has jury instructions in it. It also has a lot of important arguments in it. Some of the important arguments in it go along with what we've been talking about. Right? All laws which are repugnant to the Constitution are null and void. Marbury versus Madison, 5 yes, 137. We already argued that one. Where rights secured by the Constitution are involved, there can be no rule or lawmaking or legislation which would abrogate or abolish them. That's again Miranda versus Arizona. An unconstitutional act is not law. It confers no rights. It imposes no duties. Affords no protection. It creates no office. All right, that's Norton versus Shelby County, which we just talked about. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void. All right. 16th Am Jurisprudence, 2nd Section 177, and also 256. Officers of the court have no immunity when violating constitutional right from liability. That's Owen versus City of Independence and Maine versus Thibodeau. No state shall convert secured liberties into privileges and issue licenses and fees for them. Murdoch versus Pennsylvania. If the state does convert liberty or a privilege into a privileged citizen, can engage in the right with impunity. That's Shuttlesworth versus Birmingham, Alabama. The court is to protect against any encroachment of constitutionally secured liberties. That's Boyd versus United States. Constitutional rights must be interpreted in favor of the citizen. That's Byers versus United States. We have covered all of these cases thoroughly so that you can see clearly. All right? And we're trying to teach you how to better effectively use your Constitution. Okay? We're trying to get it down to a serious program where, what do you want to do? Open it up. All right. All right. And this book here also brings out all of these court cases. All right. Notice it's got Norton versus Shelby County in here. It's got Miranda versus Arizona. It's got Marbury versus Madison. It's got the jury has a right to judge both the law as well as the fact. John Jay, First Chief Justice, U.S. Supreme Court. The jury has the right to determine both the law and the facts. Samuel Chase, U.S. Supreme Court Justice, 1796. Singer. Alright, the jury has the power to bring a verdict in the teeth of both law and fact. Oliver Wendell Holmes, U.S. Supreme Court. The law itself is on trial quite as much as the cause, which is to be decided. Harlan F. Stone, 12th Chief Justice, U.S. Supreme Court. The pages of history shine on instances of the jury's exercise of its prerogative to disregard instructions of the judge. That's United States versus Doherty, 473 Fed 2nd 113. Alright, now... We're going to wrap up this first part here. Basically, we want you folks to hopefully not be overwhelmed. Take your time. Play the tape several times. It'll come to you. It's really not that hard. We want you to have a new reverence for your Constitution. We want you to know that a lot of brave soldiers paid for it with their life. Excuse me. We want you to know that they died miserably, some of them. And we want you to know that this is a serious, very serious thing here. We want you to know that we love you, America. And we want you to know we need your help. We need your help. We need your help to learn your Constitution so you can better and effectively come forward, pick that book up, walk out there and shake that book and say, "Shaking it, boss." All right. What's that?